Gentleman has expired. The chair now recognizes the gentleman from Texas, Mr. Gohmert, for 5 minutes.
Hello, Attorney General, down here on the end. Thank you. I know we've talked about this before, but I want to bring it up again. The Holy Land Foundation trial that occurred in Dallas, convictions obtained in 2008, there were boxes and boxes of documents that were provided to the people that were convicted of supporting terrorism. And I would like to ask again for Congress to be allowed to have copies of the same things the people supporting terrorism got before they were convicted. Will you provide those documents without us having to go through a formal subpoena process?
Yeah.
The very ones they got.
Yeah. Again, I have this note here because I asked this question. We did, in fact, promise you access to those documents that were made public in the case, but now what my people tell me is that we never heard from your staff to make those arrangements. We'll promise to make them available to you. And what I would just ask is to have your staff contact mine. And
well, then we'll work that out, all right?
You can make that happen.
And also, you had mentioned that the FBI did a good job in following up the lead from the Russians about Tamerlan Tsarnaev. Do you know what questions FBI agents asked of Tamerlan to determine that he wasn't a threat?
I don't know the specific questions.
Do you know if they would have asked if who his favorite Islamic writer was? Are they allowed to ask those questions?
I know.
Well, either you know or you don't know. Were they allowed to ask who his favorite imam was? Were they allowed to ask about the mosque he was attending at Cambridge or had been in Boston, from what I understand? Were they allowed to ask those questions?
I know a good deal about what was asked of him in connection with the interaction that occurred, but that is potentially part of this ongoing case, and that is why I'm a little hesitant to...
Well, it's also... in trying to determine how the FBI blew the opportunity to save people's lives by accepting the Russian information and following up on it. Because what we have dealt with, and I shouldn't have been classified, but the information being purged from FBI documents has been classified, and I've reviewed that information. I'm aware of what has been purged in the efforts to avoid offending anyone who is Islamic. I'm not concerned about offending anybody that wants to blow us up, but I am concerned about religious freedom, which is another topic with the IRS. But were you aware of the Cambridge Mosque where Tamerlan was attending back at the time that the Russians gave us that information?
Not at that time.
All right, well, let me tell you, he was attending a mosque in Cambridge, and obviously, if you're not sure about that, you would probably not have had anybody provide you the organization papers for the Islamic Society of Boston that was also the founder of the mosque in Cambridge, a guy named Alamoudi that I'm sure you know is doing 23 years for being involved in terrorism, also working with the Clinton administration back before he was arrested and then convicted and sent to prison for 23 years. But he started that mosque. What kind of follow-up was done on the mosque at Cambridge and the mosque at Boston where you had a convicted terrorist that was involved in the organizing? Do you know what they did about it?
All I can say at this point is that I think that what the FBI did in connection with the information they received was thorough. Are there questions of the Inspector General?
Well, thorough is an opinion. I'm asking if you knew specifically about the mosque at Cambridge, who founded it, that a terrorist founded it, the one that he attended. And it sounds like from your answer you feel satisfied it was thorough, but you don't really know what they looked at. So let me move on then.
My answer to the question is that the FBI, as I said, I think was thorough, but there were problems that were not of the FBI's making with regard to their...
Look, the FBI got a heads up from Russia that you have a radicalized terrorist on your hands. They should not have had to give anything else whatsoever. That should have been enough but because of political correctness, there was not a thorough enough examination of Tamerlan to determine this kid had been radicalized. And that is the concern I have. On the one hand, we go after Christian groups like Billy Graham's group, we go after Franklin Graham's group, but then we're hands off when it comes to possibly offending someone who has been radicalized as a terrorist. And I appreciate Ms. Chu's comment. There were people concerned about possible profiling, but I would submit, Attorney General, there were a lot more people in America concerned about being blown up by terrorists, and I regret very much my time has expired.
Well, let me just say this. You've made statements as matters of fact, and
You point out one thing that I said that was not true.
The time of the gentleman has expired. The Attorney General may...
Mr. Chairman, I would ask a point of personal privilege. He said I said something as fact that he doesn't believe was. I'd like to know specifically what it was so that I can...
Regular order, Mr. Chairman.
The gentleman from Texas should suspend because the Attorney General has the opportunity to answer the question. Once he's completed the question, if the gentleman has a point of personal privilege, he can exercise it. But at this point, the Attorney General gets to answer.
The only observation I was going to make is that you state as a matter of fact what the FBI did and did not do. And unless somebody has done something inappropriate, you don't have access to the FBI files. You don't know what the FBI did. You don't know what the FBI's interaction was with the Russians. You don't know what questions were put to the Russians, whether those questions were responded to. You simply do not know that. And you have characterized the FBI as being not thorough or taken exception to my characterization of them as being thorough. I know what the FBI did. You cannot know what I know. That's all.
Well, thank you, Mr. Chairman. And that is simply the reason. I did not assert what they did or did not do. I asserted what my point of the gentleman. I cannot have a
regular order
challenge my character.
Mr. Chairman, regular order.
Without having
gentleman will
respond to that.
The gentleman is, if the gentleman believes that he has a point of personal privilege, he can state it.
Mr. Chairman, I have a point of personal privilege. He said that I do not know that of which I spoke as being true, and the Attorney General is wrong on the things that I asserted as fact, and he has to understand the reason I asked questions specifically about what the individual Tamerlan was asked was so I would find out, and the Attorney General then sits there and actually...
Mr. Chairman, I would still assert the same regular order that I did the first time. Mr. Chairman, I would still point out regular order.
The gentleman from Texas will suspend. The gentleman's characterization of the Attorney General's answer is not appropriate exercise of the gentleman's right of personal privilege.
All right,
so
Mr. Chairman, point of personal privilege.
Right. The gentleman may complete his statement, and then we'll move on.
All right, thank you. The Attorney General made statements that what I said was not true, when actually the reverse is what happened. I asked the Attorney General what was asked. This is my point of personal privilege, and then the gentleman will respond.
No, it's not a point of personal privilege.
Yes, it is. So when you attack somebody's integrity and say they made statements that were not true, then of course that raises a point of personal privilege. But the Attorney General failed to answer my questions about what was
after he went back and regular order, Mr. Chairman.
Aspersions on my asparagus.
The gentleman is entitled to state a point of personal privilege, which he has now done, and we will move on.
Thank you.
But he does not have, under a point of personal privilege, the opportunity to characterize the answer of the witness. So the time of the gentleman...
All I was saying, for the record, was that the congressman could not know unless, as I said, something inappropriate has happened with regard to the transaction.
Or unless the Attorney General answered my questions as I asked, and then we would have had the answers.
He could not know the answer. He could not know. There could be a basis for the assertions he's made, not the questions, but the assertions that he made, unless he was provided information, and I would say inappropriately, from members of the FBI or people who were involved in the very things that he questioned me about. And I do not think that that happened.
Both the gentleman from Texas and the Attorney General have had their opportunity to clarify their positions, and we will now turn to the gentlewoman from California, Ms. Bass. Texas, Mr. Poe, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General, for being here. Yesterday, I sent you a 3-page letter with 7 questions on it. I know you haven't had time to go over those, so I ask unanimous consent, Mr. Chairman, to introduce that letter with the 7 questions for the Attorney General into the record to be answered at some appropriate time.
Without objection, the letter will be made a part of the record, and the questions will be submitted to the Attorney General.
Let me approach this kind of historically the way I see things occurring. And then I have 2 questions at the end of this dialogue. Over the last several years, government action has become suspect to many of us. In Fast and Furious, government action. And we haven't resolved that yet. We're in court, and we still haven't got a resolution on the issue that whether the subpoena should be or should not be upheld. People died in Fast and Furious. Then there's Benghazi, and there's some bungling going on, and what happened, who's responsible. 4 Americans died. But government action or inaction is suspect. Recently in Health and Human Services Department, there's accusations of improper use by people in office of their position to obtain funds to support the new health care law. We don't know if that's true or not, but government action. And then the 2 that we've been recently aware of, the AP reporters, 100 journalists, their phone records being seized, looks like bruising the First Amendment, at least to me. And by the way, yesterday I filed, Mr. Attorney General, the 2007 SHIELD law, filed that bill as well. President Obama supported it in 2007, and I hope we can get that SHIELD law passed through both houses this time. But the most recent is with the IRS and what's taken place not only with the IRS but other government agencies. And let me give you a personal case, a real person. It's a constituent of mine. Catherine Engelbrecht and her husband, they run a business in Houston. Catherine Engelbrecht decided just as a regular citizen to get involved in voter fraud and started a group called True the Vote and another group, King Street Patriots. And here's what she said in a recent interview. Quote, "We applied for nonprofit status in 2010. Since that time, the IRS has run us through a gauntlet of analysts and hundreds of questions over and over again. They've requested to see each and every tweet I've ever tweeted or every Facebook post I've ever posted. They've asked to know every place I've ever spoken since our inception, and to whom and everywhere I intend to speak in the future." That's part of her comments. We've learned that the IRS has even asked this group and other groups for their donor lists. The federal government's snooping of Engelbrecht's 2 organizations included 6 visits from the FBI, set aside the IRS, 6 visits from the FBI, unannounced visits by OSHA, and even the ATF showed up several times to investigate this organization. And the Engelbrechts, both Catherine and her husband, have been personally audited. And keep in mind, Mr. Attorney General, Catherine and her husband have owned this family business for over 20 years, never seen an auditor until all of this occurred. And yet, here we are today, since 2010, they still don't have that tax-exempt status. I've requested over the years FBI, OSHA, and ATF FOIA requests to see if they're under criminal investigation. These organizations say, no, they're not, but why are they continued to be treated like criminals? The IRS response, as we now know, they have apologized. I guess they want this to go away by their apology. But meanwhile, back on the ranch, today, USA Today reported that only one Tea Party group's been given tax-exempt status, but numerous progressive groups have been given tax-exempt status in the last 2 or 3 years. Not much of a coincidence, as far as I'm concerned. So, based on my experience, being at the courthouse as a prosecutor, you as a prosecutor, and a judge, it just seems like government credibility, because these are government actions. These are not private actions. These are government actions. Don't you think it would be best that since now FBI, ATF, which is under the Justice Department, are involved in some of these accusations of harassment, unequal protection under the law, targeting specific groups because of discrimination, I mean, those are the accusations, that we should set your department aside and say, look, we're going to get a special prosecutor here to investigate all of these organizations, all of these departments, to see if they are targeting specific conservative groups, for lack of a better phrase, for their actions, and to see if there's some violations, not of the Hatch Act, numerous law violations. I'm just asking you, do you think maybe that would help restore some credibility in your department if you set that aside and said, we're going to get a special prosecutor to clear this whole air and find out exactly what's going on in the government?
Well, I guess I would not agree with your characterization. It's a lack of credibility in either the Justice Department or any of its components.
Well, I'm giving you my opinion that the Justice Department lacks credibility and some of these departments because of the action by the federal authorities. So that's my opinion.
Okay, well, that's fine. I'll mark you as a fan, not of government. Bill Clinton once said that, the era of big government was over. I would say that the need for good government endures.
Just answer my question, because I'm out of time. I'm sorry, Mr. Attorney General. Just answer my question. Do you think we need a special prosecutor to prosecute these accusations?
And as I said, I think the need for good government endures. People talk about how government and government agencies do all these negative things, and then when it comes to Sandy, Katrina, wildfires, tornadoes, terrorism, the thing in West Texas, then people want government there. And that's my point, is that the notion that government has, or that the Justice Department has credibility problems, I think is belied by the notion that people, I think, more generally have of government and the good that government does, and the need for, as I said, for good government.
Time
I'll submit that question in writing then.
The gentleman will submit the question in writing, and we will submit it to the Attorney General. And the chair now recognizes the gentlewoman from Washington, Ms. Delbany, for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Attorney General.
The chair very much appreciates the gentlewoman's brevity and now recognizes the gentleman from Utah, Mr. Chaffetz, for 5 minutes.
Thank you, Mr. Attorney General. I appreciate you being here. I want to go back and talk about, if we could, about the investigation of General Petraeus, which I understand the FBI started in the sort of May, June timeframe. When did you first learn about the investigation into General Petraeus? Then the FBI, he was then the CIA director.
Yeah, I'm not sure. I'm not sure, but some months, I think, or a couple of months after it began. I'm not sure exactly.
The news reports say that happened sometime in the summer. Would that be a fair, accurate representation?
I think that's probably right.
Do you know when General Petraeus was notified or had any sense that he was under investigation?
I'd have to go back and look. I don't know when he was actually made aware of it by, I think, as a result of an FBI interview, I think, but I'm not sure exactly when that happened.
Do you have any idea when he would have become aware of it, other than, I see that somebody's trying to hand you something, so do you have a sense as to when he became aware of it?
This just says we'll look into it and get back to you.
Need notes for that?
I don't know. I just don't know when exactly all these events happened.
One of the questions and the criticisms here of your actions on this is that you knew about this in the summer, and yet when did you notify the director of the National Intelligence, Mr. Clapper?
I don't remember when that happened. I knew about it for a while before he was notified. I don't know exactly what the time frame was.
And when was the President of the United States notified?
It was much later. Again, I'm not exactly certain, but as I remember, like late fall, perhaps even maybe early winter. That's, again, don't hold me to these exact.
So, and I appreciate that, and I'm asking you dates, but the concern here is that you, for months, based on that timeline, and I recognize it's loose here, but for months, you knew about it, but you didn't notify the President of the United States. Why is that?
because it was an ongoing criminal investigation.
You don't think that there was any national intelligence lap over? I mean, was there any national intelligence ramification?
Not on the basis of what we were investigating. If we had thought, or if I had thought that what we were looking at potentially would have been compromising of General Petraeus or would have led to a national security problem or breach, then I.
But why? Look, according to the Congressional Research Service, let me read it from their report in April. While the extramarital affair itself is not classified as an intelligence activity, the investigation by the FBI originated with the possible hacking of Director Petraeus' email account, an act that had the potential of compromising national intelligence. As I've said before, he was not the head of the, Fish and Wildlife. Director of the CIA had been compromised, that you were investigating something. Why not share that with President Obama?
Because, as I said, we do not share ongoing criminal investigations. And if you look back, the conclusions that we reached, in fact, were correct, that we did not have a national...
Is this an ongoing investigation?
It's an ongoing investigation.
Time of the gentleman has expired. Chair thanks the gentleman for the line of questioning and now recognizes the gentleman from Florida, Mr. Garcia, for 5 minutes.
Over here, Mr. Attorney General. Mr. Attorney General, thank you for being here and thank you for your time today and thank you for your long and distinguished career. My first question, and I know you've answered some of this, but maybe in a less hostile environment, will give you an opportunity to dazzle you with your brilliance and your personal knowledge. I, unlike the majority here, know Mr. Tom Perez and have known him for many years and as a dedicated public servant. A few weeks ago, we ascended ourselves and began a confirmation hearing for Mr. Perez here, a duty and a responsibility that was beyond the purview of my office, but nonetheless we participated in that. But I'd like to hear from you as someone who's worked with Mr. Perez closely in his capacity in your office, if you could tell us about him and your view on him as Labor Secretary.
Well, I think he is uniquely qualified for this job, given his experience in Maryland in a similar position, given the way he has distinguished himself over a long and storied public service career, certainly with regard to the way in which he has conducted himself as Assistant Attorney General, showing himself to be concerned about and responsive to working class people. He's a person who I think has the ability to see both sides of an issue. He is not an ideologue, as I think he has been portrayed. He is both a good lawyer, I think a loyal public servant, who I think will distinguish himself if he is given the opportunity to become our next Secretary of Labor.
Thank you, Mr. General. I wanted to ask two more questions. One is on immigration, and thank you for addressing comprehensive immigration reform in your comments. I've noticed as someone who's been around immigration and worked with the Immigration Service that the rules that we've created has sort of bound us in certain circumstances and to some degree has limited the discretion of our immigration judges, which are overworked but sometimes don't have the legal ability or the ability to resolve many cases which seem to be simple. If we could get your opinion on returning some of that discretion to the immigration judges.
The former chairman of the committee, the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. Welcome, Mr. Attorney General. You've announced a criminal investigation into allegations that IRS employees have unfairly targeted conservative organizations. And I'm sure you would agree that when the federal government targets individuals or organizations because of their political beliefs, that is a threat to our democracy and quite possibly a violation of an individual or an organization's First Amendment rights. So far, we have allegations, I think, involving 4 cities, Cincinnati, Washington, D.C., 2 California cities, where IRS agents might have targeted conservative groups. And it so happens that a year ago, on behalf of the San Antonio Tea Party, I wrote the commissioner of the IRS asking him to look into what appeared to be targeted actions by the IRS against the San Antonio Tea Party. My first question is this: is your investigation going to go beyond Cincinnati, beyond Ohio? Is it going to be a national investigation that includes Washington D.C. as well, and includes any allegations wherever they might occur?
Yes, it would. The facts will take us wherever they take us. It will not be only one city. We will go wherever the facts lead us.
You haven't done anything to limit this to the U.S. Attorney in Ohio, for example. You're going to go nationwide.
No.
Okay.
This is something that we will base, at least we're at the beginning stages, but we're basing it in Washington, and that way we can, I think, have a better impact nationwide.
Okay. Without saying whether any criminal laws have actually been broken, what are some possible criminal laws that could have been violated if, in fact, individuals or organizations were targeted for their conservative views?
Well, I think it was Congressman Scott, I think, really put his finger on it. There are potential civil rights.
Right. But do you know of any criminal laws that might have been violated?
I'm talking about criminal cases,
okay.
Criminal violations in the civil rights statutes, IRS, that I think we find there. There's also the possibility of 1,001 false statements, violations that might have been made, given,
right.
Given at least what I know at this point.
Okay, I think some of the criminal laws that might have been violated, 18 United States Code 242 makes it a crime to deprive any person of rights, privileges, or immunities guaranteed by the Constitution. 18 United States Code 1346 makes it a crime for government employees to deprive taxpayers of their honest services. So that's a couple of examples. What civil recourse might be obtained by individuals or organizations that were unfairly targeted for their conservative beliefs?
That I'm not sure. We'd probably have to get back to you with an answer on that. I just don't know what civil recourse they might have.
I think it's possible that they might be able to recoup any expenses that they incurred trying to respond to the targeted approach by the IRS. Does that sound likely to you?
It's possible. I know that, in other instances where somebody is tried in a criminal case and acquitted, they can get their costs back at times.
Okay. Another subject, Mr. Attorney General. Last week you responded to a letter that I wrote you last year in regard to the Anti-Lobbying Act as amended in 2002. And you said in your response to me, this is a quote, "The act prohibits the use of appropriated funds to influence an official of any government," end quote. Does that apply to Health and Human Services grantees who might use those dollars to lobby state and local officials?
I'm sorry, I didn't hear the last part. Appropriate money to?
Okay, I don't know if you understood the beginning of it. You responded to my letter last week in regard to the Anti-Lobbying Act as amended in 2002, and you said that the act prohibits the use of appropriated funds to influence an official of any government. And my question to you is, does your statement and evaluation of the Anti-Lobbying Act apply to Health and Human Services grantees who may have used those dollars to lobby state and local governments?
Well, I think you might be referring to what I have only read about in the newspapers involving what HHS is doing with regard to implementation of the act, and I don't know whether or not what funds are being used or whether that letter would apply to that effort. I just don't know.
Okay. Would you get back to me then, if you don't think your statement, which is pretty clear to me that it would apply, would you get back to me as to why you think it should not apply to Health and Human Services or other government agencies that might be grantees and that would use that money to lobby local and state?
We'll do that, and given the relationship that you and I have, Mr. Former Chairman, we'll try to get back to you in a more timely fashion than we did on that first.
than a year. That would be appreciated. Thank you, Mr. Attorney General.
Gentleman's time has expired. The gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman.
Mr. Watt, you're only supposed to do that at your confirmation hearing. That's when you roll out the kids.
I'm just trying to get my line. Of course, I've been in the back listening, and Nico says you've done a good job up to this point. So,
Good morning, Mr. Issa, Chairman of the Committee on Oversight and Government Reform.
Thank you, Mr. Chairman, and I want to start by playing a short voice recording. If it comes out okay, please play it.
Hey, Greg, this is Tom Perez calling you at, calling you at 9 o'clock on Tuesday. Got your message. The main thing I wanted to ask you, I spoke to some folks in the Civil Division yesterday, and wanted to make sure that the declination memo that you sent to the Civil Division, and I'm sure it's probably already does this, but it doesn't make any mention of the Magna case. It's just a memo on the merits of the two cases that are under review of the QTAM content. So that was the main thing I wanted to talk to you about. I think, to use your words, we're just about ready to rock and roll. I did talk to David Millahog last night. So if you can give me a call, just want to confirm that you got this message and that you were able to get your stuff over to the Civil Division.
Thank you. Mr. Attorney General, that recording, as was earlier in my committee, the Oversight Committee's report, is Thomas Perez, an individual as one of your deputies, arranging for something not to be disclosed as part of his quid pro quo in St. Paul. Do you think it's appropriate for someone to, at a federal level, to try to keep information out in order to disguise what's actually going on?
I'm not sure I necessarily agree with that characterization. I'm not intimately familiar with all that happened in connection with the inquiry that was done.
Okay, well, let's just go through a hypothetical that is a little easier. You've got a case that's going to gain the United States people $180 million. You've got another case you don't want to go to the U.S. Supreme Court. You trade those two cases because you don't want to have that happen, and then you tell somebody, you know, we'd like to keep things quiet. Let's make sure we don't disclose it. Is that right or wrong?
Well, there are a whole variety of reasons why we as a government, Justice Department, decide not to become involved in QTAM cases, the strength of the evidence, questions of law, position of the...
Is it okay to trade a case you don't want going to the Supreme Court for a dollar damage case? That's the real question here.
Well, one has to take a look at this in its totality and decide exactly if there were...
Okay, I'll take that as a yes. It's okay to do that trade in your mind.
That was not a yes. It was not a... I was trying to answer the...
Okay, well, you know, Mr. Attorney General, I need a yes or a no before you go into the long dialogue. Otherwise, I'm wasting my time. There was a quid pro quo. There was a trade of $180 million worth of revenue to the American people in return for dropping a case that your Justice Department did not want go before the High Court, to coin the phrases used, bad facts make bad decisions or bad law. Now, I understand you or at least Mr. Perez didn't want things going to the Supreme Court, but let's go through where we are today.
Well, the decision not to take over the False Claims Act case did not end the case.
Well, you may say that, but the plaintiff who saw himself abandoned didn't see it that way. But let me go on to another line of questioning.
The ability to try the case, I don't think it worked out well as I understand it, but the case was not over simply because the United States did not become involved.
Right, but the case going to the U.S. Supreme Court was over.
We do not become involved in QTAM cases 80% of the time.
The case going to the U.S. Supreme Court was over as a result.
Well, as the decision was made not to pursue that case.
Okay. So the American people were denied the highest court considering a case. That's an undeniable fact. Let me go through some questions here.
That's incorrect.
I've been working with...
that is a fact.
Well, we'll let the people decide whether they were denied a Supreme Court decision.
Typically you do, but
Mr. Attorney General, Thomas Perez falsely stated to our committee that he had apparently none, then one, then two, then 34, then 35 emails that violated the Federal Records Act. Your office has only, I think yesterday or today, allowed us to see in camera the to and from on these emails. We have not seen the contents. But in seeing the to and from...
Mr. Chairman, I have a parliamentary inquiry, please.
The gentleman from California will suspend. The gentleman will
and I thank
her parliamentary inquiry.
I thank the gentleman. First of all, I would like to know, I've been on this committee for more than I would like to count. Was there notice given of this recording to be played I have not, in the life of the time that I've been in this committee, heard a recording.
The
Was
gentlewoman,
a minority noticed on this recording?
the gentleman
Is this
was,
a hearing about Mr. Tom Perez, or is this a question about?
gentlewoman will
Department
suspend. The
I'd
gentlewoman
be happy
is,
to yield to you. First, I would like to know, has the notice been given, was the Attorney General's office given notice about a
the
recording?
gentlewoman will suspend and the chair will answer her question.
I'd be happy.
There is no requirement under the rules of the committee that a member cannot use evidence before the committee as a part of the hearing.
Mr. Chairman, if I could clarify for the gentlelady.
I'd be happy for the gentleman to do so.
That recording was produced by the Justice Department. It is a piece of evidence that came from the Attorney General. So I would hope that playing back his own evidence would not be unreasonable.
Let me just, if I can continue this.
The gentlewoman may state a parliamentary inquiry, and that's all, because the gentleman from California has the time.
I do understand it, and I appreciate it. So may I hear this again? Are you saying that evidence can be presented, but the question I asked was the Attorney General given notice that this recording would be played?
There is no requirement under the rules of the committee that a witness before the committee be given evidence of or notice of evidence that may be presented to the witness at the hearing.
Continuing my further inquiry, as I think I heard the gentleman from California make a point, but has this been authenticated as the actual true voice for the individual who's allegedly on it?
If the gentlelady would yield, Thomas Perez has owned up to this being his voice.
Well, then the only thing, if I might continue.
The gentlewoman has not stated a valid parliamentary
If I may
inquiry,
continue it
and
so
the
that I might
gentlewoman
say-
will suspend, and
Yes.
the gentleman from California will be recognized for the remainder of his question.
Mr. Chairman,
Mr. Chairman, I would
point of
ask
order.
that I have just 2 minutes to conclude.
The gentleman's time will be restored to 2 minutes. And
I would not want to, can I make a point of order, Mr. Chairman?
What is the gentlewoman will state her point of order?
Point of order is that Mr. Perez has authenticated his voice. Is the general authenticating his voice by answering the question? How is he authenticating
the
Mr.
gentlewoman?
Perez's voice?
The gentlewoman will suspend. That is not a parliamentary inquiry,
I'm going to
nor is
point
it
of
an
order, Mr.
appropriate point of order.
Chairman, I demand
because
regular order.
I thank the chairman for his courtesies.
The gentlewoman's point of order is not well taken because there is no such rule that would require this committee to treat this like we were in a trial. This is an opportunity for members of the committee on both sides of the aisle to ask questions of the witness, and the gentleman from California will continue his line of questioning.
Thank you, Mr. Chairman. Mr. Attorney General, our investigators have seen 34 of the 35 admitted emails that violate the Federal Records Act. They have only seen the to and from. They have not seen the deliberative contents, and they have not seen the remainder of the 1,200 emails. Mr. Cummings, my ranking member, joined in a letter requesting that we have the full contents pursuant to our subpoena of all 1,200. Will you make them available to the committee based on our bipartisan request?
I will certainly look at the request. It's not something that I have personally been involved in, but I'll look at the request and try to be as responsive as we can. I'm sure there must have been a good reason why only the to and from parts were.
Yes, you didn't want us to see the details. Mr. Attorney General, knowing the to and
That's what
from,
we typically do.
knowing the to
I'm
and
not going to stop talking now.
Mr.
Characterize something as something
Mr. Chairman, would you inform the witness as to the rules of this committee?
Appropriate and is too consistent with the way in which you conduct yourself as a member of Congress. It's unacceptable and it's shameful.
The gentleman has the time, and the gentleman may ask the questions that he deems appropriate.
Thank you, Mr. Chairman. In these email headers, one of them was to Melanie Barnes, Domestic Policy Counsel. In other words, it was to the White House. We have not seen the contents. Secondly, one of them was to Sarah Pratt at HUD. Now, that is germane to our discovery of this quid pro, but more importantly, it is to an AOL account. So communications went on between two government officials, both of whom were circumventing the Federal Records Act. Additionally, in these emails, we learned that Thomas Perez has yet another non-government account which he uses for government use. So in addition to his Verizon account, he has an RCN account. Would you agree to make all of this available to us, since first of all, it violates the Federal Records Act and your own rules. Second of all, it is pursuant to a legitimate use of Congress under which we would have it. And lastly, because you've asked for transparency, and before you answer, if you would please, in the AP case, you have appointed Ronald Manchin, U.S. Attorney, and I'm sure he's a fine U.S. Attorney, but can he be considered to be independent when, in fact, when this Congress held you in contempt, he was the individual who refused on your orders to prosecute the case? If he will obey your orders and not living up to a contempt of Congress, can we believe that he is in fact independent?
Mr. Chairman, I'd ask for regular order.
We have regular order. The gentleman's time has expired, but the Attorney General is allowed to answer the question.
It expired 45 seconds ago.
Well,
Mr.
first
Chairman.
off, I mean, I did not order Mr. Manchin not to do anything with regard to, I won't characterize it, the contempt finding from this Congress. He made the determination about what he was going to do on his own. That's not, I didn't have anything to do with that. With regard to the email requests, I think that if your request is for relevant emails that have something to do with the subject matter that you are looking at, that is certainly something that I think we should consider. With regard to the entirety of his email accounts at 1,200 or 1,300, I'm not sure what the number was that you used, if they don't have anything to do with the matter at hand, I'm not sure why they should be turned over.
Mr. Chairman, point of inquiry. When Congress issues a subpoena, in your understanding, is it to be determined, or for that matter, when the Justice Department issues a subpoena, is it a decision of the recipient as to what is germane, or is it a decision of the subpoenaing authority?
That is a question of beyond the scope of this hearing, but
we have a few lawyers present.
We have many lawyers present. And certainly it's the opinion of the chair that the subpoenaing party would determine the scope of their inquiry. If the respondent does not agree, then it would be appropriate for a court, and we hope that a court will soon decide the appropriateness of that subpoena, because it is very disappointing that this has not been responded to and that the Congress found it necessary to take the action that it took.
Focus for a moment on the Boston terrorist defendant while he was in the hospital, if you would please. Why were charges filed at that particular time instead of waiting for just running the time more so on the public exception of Miranda? I understand it was about 16 hours and then charges were filed. Certainly the magistrate doesn't have the right to go in and do that in and of themselves, so charges had to be filed. He was in the hospital, so as a result, the magistrate is brought there, but also a public defender was brought there. But why at that time? Why did you make that decision, or who made the decision to file charges at that time?
Well, let me just not talk about that case again, ongoing all that, but charges, I mean, there are rules that we have. The Supreme Court has said that with regard to detention, you've got 48, in essence, 48 hours to bring charges. And what we did there was to do things that are, I think, consistent with the rules, while at the same time, and without getting into too much, while at the same time using the public safety exception in the best way that we could.
I don't want you to get into anything that would jeopardize this prosecution, but there was time. You could still have used the public exception rule to allow the FBI to interrogate this individual before Mirandizing. Do you agree with that?
Yeah, the Justice Department and the FBI agents never Mirandized.
No, that's not my question. I know they didn't Mirandize him because they didn't have to because of the exception. But it seemed to me that there was a rush to file the charges that would then force the magistrate to inform the defendant of his rights. Why did you not let that time run longer so the FBI could question him?
The charges were filed at about, from the time of capture, about 46 hours after that. So that's
But that's a benchmark, correct? The 46 hours is a benchmark. I mean, I've read a case where it has been days where the exception has continued. All right, was that discussed with Director Mueller? Did he know prior to that charges were going to be filed?
Yeah, we worked with the FBI both in Washington and in Boston. Everybody was aware, and the state and local folks as well. Everybody was aware of how we were going to proceed.
Okay. Why weren't state charges filed? Then you would have more time to question an individual before you had to file federal charges. As a former prosecutor, both at the state and federal level, I mean, we use these tools to our advantage.
Well, after the bombing, the decision was made, and I think correctly so. The Joint Terrorism Task Force got together and made a decision that this was going to be a federal matter, a federal investigation, and that federal rules applied.
Let's switch gears here once to your recusal in this other situation. I got into a little argument with Justice Department on cases where I not only recused myself, but I wanted my entire office recused. Now, you're in a little different predicament here, but I always followed it up with written documentation, letters saying why I'm recusing myself, why I'm recusing my office, making sure there's a paper trail from here to yesterday filed in my office and with Justice Department. Are you saying that there's no paper trail here when you recused yourself, and for what reasons?
I don't think there is. As I said, that's something that we were looking for, and nothing has been found. And I'm not sure somebody else raised that point. And as I've thought about it, actually during the course of this hearing, that actually might be a better policy to have in place.
I would think recusals. So. They have those documents in place. You also have the authority to appoint special prosecutor, whether it's a sitting U.S. attorney or someone outside of justice completely. So you have the deputy who gave the approval, but yet is heading the investigation. Don't you think there's a conflict of interest there, and someone else should be appointed to handle this matter?
I'm not sure I understand. Did somebody other than the deputy should be handling this?
Yes, as far as the investigation is concerned.
See what you mean? Okay. Well, I made the determination, and was criticized at the time, for making the determination that the prosecutors, that the U.S. attorneys in Maryland and the District of Columbia could handle these cases in a fair and appropriate way.
I'll be the last guy to criticize you about a U.S. attorney handling a case, no matter where he or she is. Being one, I know the caliber of people that work at justice. So be that as it may, I see my time has expired. Thank you.
Thank you.
Chair, thanks. This is the gentleman from South Carolina, the chairman of the Immigration and Border Security Subcommittee, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, Mr. Attorney General.
Good afternoon.
Do you think it's reasonable to evaluate how effectively prosecutors and law enforcement are using current firearm statutes as we debate whether or not we need additional firearm statutes?
Sure, that ought to be a factor, but I think we are using the laws effectively.
Well, I would have to take your word for it for this reason. I wrote you 6 months ago and asked for statistics specifically on two code sections, 922D and 922G, which deal, as you know, specifically with the possession or transfer of firearms by those who have been adjudicated mentally defective or committed to mental institutions. I wrote that letter in December, thinking that being a low-level House member wasn't enough to garner any attention. I then got a senator to co-sign the exact same letter with me, and we have not heard back yet. So you agree that it is relevant how effectively those code sections are being prosecuted as we evaluate whether or not we need additional tools?
Excuse me. I think that we should take into account all of what we're doing in terms of weapons prosecutions. 1/7 of all the cases that we bring in the federal system are gun cases.
What percentage of current background check failures are prosecuted?
A much smaller number. There were 83,000 background check failures in fiscal year 2012. There were 85,000 cases brought. Much smaller number of those failures were actually brought. The purpose of the background check system, though, is to prevent people from acquiring guns. 1.5 million have been stopped since the beginning of the system, as opposed to the prosecution. And that's what
I understand. I understand that, Mr. Attorney General. I also understand a little something about a lack of jury appeal. I know certain cases don't have tremendous jury appeal, but when you're advocating for increased background checks, and it can be argued that you're not a good steward of the current background check laws that you have, I just frankly think it undercuts the argument. But reasonable minds can differ on that, I suppose. I don't think reasonable minds can differ on 922D and 922G, which deal with people, these are not my words, it's in the statute, been adjudged mentally defective or committed to a mental institution. If you want to search for a theme throughout lots of our mass killings, I think we'll find that theme. I want to read to you a quote that's been attributed to you. If the quote is inaccurate, I want to give you a chance to tell me it's inaccurate. I'm not going to read the whole thing, but creating a pathway to earn citizenship for the 11 million unauthorized immigrants in this country is essential. This is a matter of civil and human rights. Is that an accurate quote?
Yeah, I think that's a speech I gave at the Anti-Defamation League.
All right. Well, you would agree with me that persons who can't pass background checks should not have the civil right, as you call it, of citizenship.
Well, as I use that phrase, I didn't use it in the strictly legal sense.
But Mr. Attorney General, with all due respect, that's the problem with using the phrase. Well, that's the problem. I mean, you are a highly trained lawyer, and you know what the phrase civil right means. And when you say that you have a civil right to citizenship, when you have broken the law to come to the country, that comment has consequences, and surely you have to know that.
With all due respect, it was my speech, and those were the words that I chose, and I did not mean to convey, and I didn't think that it would be taken that way. Some have said that, many have not, that meant that there was a legal right or anything like that. It was in the context of that phrase where I said civil and I think human right. I think that's the word that I used there.
Right, but you can understand how it's problematic for those of us, frankly, who are working on immigration reform and don't come from districts where it's a really popular political idea, to have the Attorney General say you have a civil and human right to citizenship even though you're in the country in violation of our laws. That's a non sequitur, and it's hard for some of us to explain that. So I don't know what you meant. I just know what you said.
Yeah, and what I meant was that you've got 11 million undocumented people here who are, we must admit, contributing to this country in substantial ways, but oftentimes are exploited because they are in that undocumented status.
But Mr. Attorney General, my point is all 11 million aren't valedictorians, which is why every bill has a background check provision. And all 11 million don't want citizenship. So to call it a human and civil right, speaking for a broad group of 11 million, I'm just, with all due respect, it's just not helpful to those of us who are trying to be part of the conversation.
Sure.
But
and I didn't mean to say by that all 11 million either want to be citizens, you're right, or will ultimately, as the bills have been crafted, and I think appropriately so, will pass the necessary background checks. But I'm talking about the universe of people who we do have, which is generally accepted as 11 million. And from that 11 million, and I suspect it's going to be a large portion of that 11 million, will pass background checks, will desire to become citizens, and then will be entitled to the human rights that all Americans have after they go through that period that allows them to acquire citizenship along that pathway.
I'm out of time, Mr. Chairman.
If she has additional questions, please submit them for the record. And the chair now recognizes the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank the chair. Mr. Holder, you announced last Friday a criminal investigation into the IRS. I really only have one question. Will you assure Congress and the American people that your investigation will not impede or slow the investigation Congress is doing into the Internal Revenue Service? And here's why I'm concerned. We have heard you today say, we lost track. We actually keep a track of, we started having a little tally. How many times you said ongoing investigation? But the one that comes to mind for me is Solyndra. And I would argue that investigation has netted nothing, no new information to Congress, and has only impeded and slowed down our investigation into that company that went bankrupt and lost taxpayer money. Next week, Chairman Issa has announced Lois Lerner and 3 other witnesses will be in front of the Oversight Committee next Wednesday on the IRS issue. I know for a fact Lois Lerner lied to me. She lied to our personal staff. She lied to committee staff. She lied in correspondence to Mr. Issa and myself that we had sent her written correspondence. And here's what concerns me, is because there's now a criminal investigation, next week when Lois Lerner, who lied to Congress, and therefore the American people, comes in front of our committee for us to get information about what took place at the IRS, is she just going to throw up her hand and say, you know what? Attorney General's Department of Justice is doing a criminal investigation. I can't really comment now. And that is I think, a concern that members of Congress have, and certainly the American people. So again, will you do everything you can, and what assurances can you give the United States Congress that that, in fact, is not going to take place?
Well, I think the responsibility I have is to investigate violations of the law, and I think what we will try to do is to work with Congress so that we don't get in your way, you do not get in our way.
But the point is, it's already happened. It's happened with other issues, and this is the big one. This is people's First Amendment rights being violated. We want to know, what are you going to do different this time? And let's just be frank, well, Mr. Holder, you don't have all that much credibility. There are lots of folks on this panel. I'm not one of them, but there are lots of folks here who have called for your resignation. You've been held in contempt and a host of other things. So this is why this question, I think, is of paramount importance.
Well, again, to be frank then, your characterization of Ms. Lerner as lying before Congress by itself, I mean, forget about the investigation.
We'll be happy to show that, and we're going to show it next week, but we want her to be able to respond to us and not say, oh, I can't comment because Mr. Attorney General has got a criminal investigation going. We will show that next Wednesday.
I understand that, but your characterization of her testimony in and of itself, in the way you have characterized it, could, forget about our investigation, could put her in the very situation that you say you don't want to have happen. So it might not.
That's already out there. She's done responded. We have it in writing. There's no news there. It's a fact. I want her on the witness stand and be able to answer our questions. And what I don't want her to do is say, oh, I can't, because the criminal investigation is going on in the Department of Justice.
She could justify, on what the basis of what you said, forget about the investigation. On the basis of what you said, she could say, I can't answer this question because you think that I've already lied and I might be charged with a false.
There's a much stronger, you know this, there's a much stronger likelihood based on what you're doing than what I just said here.
Well, as I said,
we know that's the case.
Our responsibility is to investigate violations of the criminal law. We will do that. We will try to work with Congress in a way that we don't impede that which you want to do. In the same way, I would hope that Congress will work with us so that you don't impede our criminal investigation and ultimately hold people accountable. There is certainly a role for Congress to play in exposing what has happened, but I think we have the ultimate responsibility in holding people accountable, and that is something that is uniquely the ability of the executive branch to do, not the legislative branch.
Mr. Chairman, I yield back.
Some of us have deep bass-like voices. Might sound that we're not being friendly and happy, but I would appreciate a little civility in the questioning of the Attorney General as we proceed to the conclusion. I yield back.
The gentleman from Georgia may proceed.
Thank you, Mr. Chairman. In opposed to this, I just have just a simple question. It was amazing to me that the question was, did you not think that you would be asked about maybe the timeline on when you might have recused yourself? Because you also said at one point you recused yourself before subpoenas, or it was that there was some question even in your own dialogue about when you actually did this. So I'm just asking a simple question, and as the others on the other side, they've got to ask their questions. I'm now asking mine. Did you not think that someone on this panel would have asked you those questions?
I did not know whether anybody would ask me that question, but irrespective of that, I thought that was an important factor, an important fact, and it was one of the reasons why I asked my staff to find out, irrespective of what was going to happen up here today, whether or not there was in writing a recusal. I asked that question myself, thinking that it was an important question. I did not know. I don't know what you all are going to ask me. So that's why I was saying I didn't know whether or not you were going to ask the question, but I thought it was an important one and one that I put to my staff.
In light of the impartation of my time, I do have one question on that regard. Have you recused yourself in using your recusal? Have you put that in writing before?
I'm not sure about that. In Mr. Holding's case, the Edwards case, I recused myself in that matter. I recused myself in other cases because my former law firm was involved in those cases. I'm not sure that those are in writing, but I do think, as has been raised, I don't remember what congressman, that putting these things in writing would, I think, might be the better practice.
Mr. Attorney General, I appreciate your answers to your question. This is an issue that needs to be done. It's just amazing. Again, as you have stated, there's a role of the executive.
Mr. Chairman, point of order. Is that light red right there?
The gentleman's time was interrupted considerably by a debate over whether or not he was entitled to ask his question, so he can complete this question, and the Attorney General can answer it.
I said
and I did not interrupt the gentleman either from Louisiana in his question, so I just appreciate the opportunity to close. And the opportunity to close is I appreciate your answers. We're going to ask more of these questions, and these are the roles that we both, in your role and our role, play. And with that, Mr. Chairman, I yield back.
Well, that's fine. And I respect the oversight role that Congress plays. This isn't always a pleasant experience. It's one that I recognize that you go through as an executive branch officer. The one thing I've tried to do is always be respectful of the people who've asked me questions. I don't frankly think I've always been treated with a great deal of respect, and it's not even a personal thing. If you don't like me, that's one thing. But I am the Attorney General of the United States, and I'm not. This is the first time you and I have met, so I'm certainly not referring to you or any of the questions you just asked. But I think that is something that is emblematic of the problem that we have in Washington nowadays. There's almost a toxic partisan atmosphere here, where basic levels of civility simply don't exist. We can have really serious partisan fights, disagreements about a whole variety of things, but I think people should have the ability, especially in this context, to treat one another with respect. I've tried to do that. Maybe I've not always been successful, but I certainly know that I have not been treated in that way all the time.
The time of the gentleman has expired. The chair recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, I'm going to talk about credibility and accountability because I think this is kind of something that is underneath all these issues we've been dealing with. And as I understand your testimony today with this AP case, something that bothers me is that, by your own admission, this is one of the most serious leak cases in the past 40 years. Your comments yesterday, you said it put the American people at risk. And yet, as you testified today, you don't know when you recused yourself, you have no record of you recusing yourself, and you didn't tell the White House that you recused yourself. And that bothers me because that explanation, one, I think is insufficient, and two, it insulates you and it insulates the president from any accountability about what happened. So is this really the best you can do in terms of explaining what you did for one of the most serious cases that you've ever seen in your professional life?
As I said, with regard to the question of how recusals are memorialized, I think writing a written response would make a great deal of sense. But the notion that I would share with the White House information about an ongoing criminal investigation is simply not something that I, as Attorney General, unless there is some kind of national security, serious national...
Which there was by your own admission, to put the American people at risk, correct?
But we are talking about a limited group of people who had access to this information, some of whom were in the White House. And so the notion that I would share that information with the White House, I didn't share this information with people in the Justice Department. I mean, it was
but the people in the Justice Department, with all due respect, are not responsible for protecting the American people. The president is. So we just have a disagreement on that. Now, in terms of
the Justice Department, we are responsible for protecting the American people.
The buck stops with the president in terms of a serious risk to the American people. I understand they have duties to enforce the law. They're important duties, but ultimately the president is who we rely on. Now, in terms of with this Internal Revenue Service issue, do you agree? I mean, you're the head lawyer in the entire country, and your office, you are due respect for your office. Do you acknowledge that the IRS is a part of the Treasury Department and it is accountable to the president and that it is not an independent agency?
I don't know. I've heard that it's an independent agency. There is some kind of reporting responsibility within Treasury. Exactly how that is defined, I don't know.
You've been in law for 40 years. You're one of the most accomplished in terms of the positions you've had, and you don't know whether the IRS is a part of Treasury, whether the IRS commissioner is responsible to the president, or whether it is considered an independent agency. You really don't know the difference between those?
I didn't say that. I said the IRS, as I understand it, is a part of the Treasury Department. The IRS commissioner is independent, but is appointed by the president to a fixed term.
And can be removed at the will of the president, correct, per federal statutes?
All executive branch employees can be removed.
Okay, so then it's not an independent agency, right? Is it? Can we just understand what it is?
I'm not sure where you're going with this question. If you're trying to put what the IRS did into the White House, that's not going to work.
No, it's not. Is it an independent agency, yes or no?
It is an independent agency that operates within the executive branch.
Well, then it's then that's completely begging the question. See, the president and the press secretary have said that it's an independent agency, that it's outside the purview of the executive branch. And my point is, yeah, maybe the president's not micromanaging every decision, but that IRS commissioner is accountable to the president, and the president can remove that individual. If the agency was truly independent, then the president would not have that authority to remove that individual. And so I think we need to be clear when we're making statements, and you had made that statement before today, but the White House press secretary and the president did, and I just don't think it was accurate. One more thing, with these Benghazi terrorists.
You have a question? I know. Okay, I'm sorry. Go ahead.
With Benghazi terrorists, I know nobody's really been brought to justice for this. I know the FBI was over there investigating. At this point in time, is this your purview to bring those people to justice, or is it a military issue? Who's in charge of exacting justice for the terrorists who killed 4 Americans?
It is the responsibility of it's my responsibility. It's ultimately, I think, my responsibility. And I mean, it's now, what, 7 minutes after 5 on whatever today's date is. And as of this date, this time, I am confident and proud of the work that we have done in determining who was responsible for the killings in Benghazi.
But there's not been any action taken to bring them to justice?
None that I can talk about right now.
Okay, very well. Thank you, Mr. Attorney General. Mr. Chairman, yield back the balance of my time.
Let me just say that in response, to add to that last response, that because I'm not able to talk about it now does not mean that definitive, concrete action has not been taken. That should not be read that way. We have been aggressive. We have moved as quickly as we can, and we are in a good position with regard to that investigation.
Can I just 5 seconds to follow up, Mr. Chairman?
That's fine. The time of the gentleman has expired.
That's okay. That's okay.
The Attorney General is going to give you 5 seconds.
Can you say whether the concrete action?
He has to call me Mr. Chairman.
Can you say whether the concrete action is law enforcement based or in terms of military based, being a kinetic response?
I can say that within the purview of the things that we do in the Justice Department, definitive action has been taken.
Now the time of the gentleman has expired, and the chair recognizes the gentlewoman from Texas for her unanimous consent request.
Mr. Chairman, thank you for your courtesies. I'm glad we're ending on a smiling note. I have 3 documents. My first document is this is the title of it, AAG Perez restores integrity to the voting section